Section 124 of the Social Welfare Act 2005 meant that only those married or in a civil partnership would get the benefit of the widower's contributory pension. And the Supreme Court has found that that is unconstitutional, and it's arbitrary and it's capricious and cannot be objectively justified. That's what the Supreme Court has found in the case of the gentleman John O'Mara. He was deceased by his long-term partner, the mother of his 3 children. He was looking for a widower's contributory pension. He, remember, had paid the same PRSI contributions as a married person or a person in a civil partnership. But John O'Mara wasn't married and was not in a civil partnership. Nevertheless, she was a long-term partner, the mother of his children, who tragically passed away in the last few years. I think from COVID-19, actually. She had some complications, I think, arising from cancer. Anyway, the loss and the loss suffered by the bereaved parent and the obligations to the children are the same loss and obligations as a married parent or one in a civil partnership, the Supreme Court has held. And it has looked to a particular article of the Constitution, Article 40.1, which says that all human persons are equal before the law, and therefore the particular provision, Section 124 of the Social Welfare Act 2005, which basically discriminated against persons who did make contributions, etc., but were unmarried, that could not be objectively justified and was unconstitutional. So this is going to have a significant impact for non-marital families in looking to vindicate the rights, because they're not looking to rely solely on family. They are looking to vindicate the rights based on the constitutional right to equality, which is the guarantee under Article 40. Remember, Article 41 is the one which deals with special protection to the family. So the practical effect is that this man, Mr. O'Mara, in addition to thousands of people, will become eligible for the widower's contributory pension payments. Unfortunately, he is reliant now on the government, who must enact legislation for the legislation to be changed and for the payment of the widower's contributory pension to bereaved unmarried parents. And he will be entitled to the widower's contributory pension and should get backdated payments, but other bereaved unmarried parents are expected to get prospective, that is, in the future, payments only. And the census apparently in 2016 in Ireland found that there are 151,000 cohabiting couples in the state, with about half of those living with children. The situation with unmarried couples who do not have children, that's slightly more complicated, and it's not clear what the position is there. But the court's ruling was kind of reliant to a great extent on the fact that Mr. O'Mara was a parent of these 3 children. He was a bereaved parent, and the court took the view that any entitlements of bereaved children or bereaved child's cohabitees would require a separate determination in an appropriate case. So it's a bit unclear about unmarried cohabitees without children, but certainly married or unmarried cohabitees with children will look forward to the government basically enacting legislation to give effect to what the Supreme Court has decided in this case involving the widower's contributory pension, and it is based on the finding that Section 124 of the Social Welfare Act of 2005 is unconstitutional.